very good evening to you. You're watching News 9 Digital. I'm Pratibha. Thank you for joining me live today. Today we're going to talk about something that could affect us all, is affecting us already in subtle ways, but in much more profound ways in the near future. A scary statistic shows that 2019 witnessed a 25% jump in sedition cases, with Karnataka topping the list. So does that mean that cases of sedition are on the rise across the country over the last 1 or 2 years? Maybe, but conviction rate remains abysmally low. The investigators could manage to get a conviction in just 1 out of the 30 cases whose trials were completed last year. And in the case of 29 other people, they were let off as the charges did not really stand in court of law. So last year recorded the lowest conviction rate at 3.33% and it was 33.30% in 2016, just to give a comparison. Well, of course, the debate on sedition laws is a long-standing one. While activists have been demanding the repealing of the section 124A of the Indian Penal Code that deals with sedition, the government is quite clear on its stand as well. It has already declared in Parliament that it is not on its agenda, that it's not taking any steps to repeal the law at present because it's needed in effectively combating anti-nationals, secessionists as well as terrorist elements. So sedition, of course, is a non-bailable offence. Punishment under the law varies from imprisonment up to 3 years to a life term and fine as well. So with sedition cases seeing an all-time high, we need to ask ourselves several tough questions. With such low conviction rates, has it now become a law to intimidate anyone who speaks against the state, or is it even serving the purpose of combating terrorist elements, as the government has said? To discuss more on this, distinguished advocate B.T. Venkatesh joins me live. He is known to, of course, tread the path that many fear or dread to take. He has taken up cases when many lawyers did not want to as well, like the sedition case that was filed against the Kashmiri students in Hubballi. Mr. Venkatesh, many thanks for joining us. 150 years of the law, it's still alive and kicking. It's quite a scary statistic that we are looking at as of now. 25% jump in sedition cases. Karnataka gets the dubious tag of the highest jump in cases. How do you look at it?
Hello?
Yeah, can you hear me?
Yeah, loud and clear.
Mr. Venkatesh, Karnataka seeing the highest jump in sedition cases, a big spike that we are seeing in 2019 as well. How do you look at it?
Yeah, the question here is that first, as any sane citizen would expect, this law should be not in records. It has no place. When you have freedom of expression, no sedition. Sedition, in fact, we have done a series of discussions on this. In fact, we had a very wonderful discussion in our Rich Lawyer Friday talk show on courting contempt in respect of Prashant Bhushan's case. In the course of it, we had discussed on this sedition as well. That today, any criticism, any dissent as against the government is being termed as sedition. I think that's not the purpose of this particular law. In fact, this was a law which was enacted by the colonial government.
Yeah.
British government, which wanted that no one should talk against the government. They were masters of the country at that point of time. So anything against the disaffection against the government is something. What's disaffection? Disaffection is that they are outsiders. The colonials are outsiders and they did not want anyone to talk against it. And there is a very famous case of MacLeod versus Sabay in 1899, I think 1899, yeah. There is the case, very famous case. In that particular case, the scandalizing court was one of the things, and they also sought it for sedition on that particular aspect, treason, everything, contempt of court, many of these. In that particular matter, the court held that, in a free society, these things do not matter. There can't be a citizen of the UK will not be prosecuted for that, whatever he does. It's only a subject
Okay.
who is liable for a special subject in the colonies. smaller colonies. That was the statement made in that particular judgment. So where we have come to in all these years, are we still subjects? 70 years after Republic, if we continue to have a law meant for subjects, you understand the difference between a citizen and a subject. Subject is somebody whom I have control over.
So it's draconian and
Citizen
quite regressive.
A citizen is someone who makes the nation. Subjects don't make the nation. Subjects are part of my nation, kind of thing. So the kind of difference that we have in respect of subject and citizen, this law is applicable to subjects and not citizens.
Okay.
And in fact, this was squarely discussed in Kedarnath's case, in fact, one of the major cases. The most important constitutional judgment, even as on this day, that stands on the subject is that of the judgment came when I was born, 1962. The case speaks in terms of the law being valid. However, the way it is understood should be that all the aspects which would go to show that there should be some substantive material. It should have led to violence. It would have led to such situation. It's impossible. Then you can press into service sedition.
Okay. But you know, in 2019,
one of the major one aspect which you should look into is, and most of us we forget in our rush to answer these things, is that the proviso to Section 124A, subsection 2 of Section 124A. We don't look at it at all. When it amounts to disaffection, it's not just some statement against the government. Today, what's happening in Karnataka, suddenly you come today with me saying that there is a substantial jump in cases of sedition in Karnataka. Today, good number of cases of seditions are registered in Karnataka or any part of India are not relatable to the sedition at all. In fact, they can't stand the test of Kedarnath judgment. That's a test which is fixed. It has to stand the test of that particular Kedarnath judgment. They can't stand the test of the Kedarnath judgment. Very simple reason which you just narrated now, that most of the cases are acquitted. Yeah, simply because they don't stand the test of Kedarnath. But how come these cases are being registered? In fact, it has been said by Supreme Court in unequivocal terms, please don't press this into service anytime you want.
Okay.
It has been a statement of Supreme Court. Supreme Court has chided governments that they should not press this law into service. One of the major aspects of this particular 124A has been from 1947, even after securing freedom from the British colonial rule, we have been using this law left, right, center. And it has been used by and large to silence the voices of dissent. A good journalist, a senior journalist, in fact, it was always targeted against the media. Throughout. Or the activist who is talking about it. And this has seen a change over a period of time today. Anyone, in fact, we had this case in Bidar where I was representing the accused in that case. The two women. One was a housemaid and another was a primary school teacher. They were saddled with case of sedition because a child spoke a word in the play. Now, they have gone down to, and somebody complained after 1 week. How can anyone complain? The complaint of sedition has to be filed by the state. State is aggrieved. It's not individual who is aggrieved. State is aggrieved. State feels that there is a threat to it.
Okay.
The state should lodge a complaint.
Okay.
Not every Tom, Dick and Harry who comes to the street and files a complaint. Today, look at the complaints that we have.
Right, we have an increase in cases, but also Mr. Venkatesh, talking about the increasing cases that have been coming in, like you said, the conviction rate is quite negligible. It could be because of various reasons, because it might be for frivolous reasons that the complaint was lodged in the first place. It could also be because there was no evidence for it. But would you say that in several of these sedition cases, the process itself becomes the punishment? Is it a bigger message being given out to those involved?
It's only to see that silence the voices, one of the major tools, silence the criticism, silence the freedom of expression. I think this is used extensively for that.
Okay.
And it's not one regime, almost all the regimes in the last 70, 80 years that we have been, 74 years, we have been seeing this being employed. To any dissent, serious dissent is prosecuted under sedition. And they don't stand the test because they can't stand the test.
Okay.
Because there is nothing seditious about expression. I can criticize you. The very construct of democracy is criticism. If I don't have freedom of expression, where is the democracy? In fact, the whole construct of democracy is a joke if you can't have the expression. And I'm critical of the government. Criticism of the government, where you find there is a very heavy criticism of the government, you can say that democracy is at play. Where there is no criticism of the government, that any criticism of the government is taken so serious that people are being prosecuted and sent behind bars, then in that case, this democracy is under threat. When there is no criticism at all of the government, then it means that we are living in a totalitarian state. So it's only in a totalitarian state you will not hear any of this particular kind of noise. You will not be conducting a program like this. You will not be permitted to conduct a program like this. So this is something which is known to all of us. And judgment after judgment, Supreme Court has always held, what is sedition? When you can press into sedition, who can press sedition into charge? And which are the rare circumstances? It's like death penalty.
Okay.
Every murder, you are not going to sentence a person to death penalty.
Yeah.
It's only in the rarest of the rare cases. Rarest of the rare cases, the court will say that they are imposing death penalty. Otherwise, it will not. Now, here, sedition is also very rarely used. We should be very rarely used. In England, they have removed that. Good number of countries in the world have removed sedition as law because it does not make sense to have a law like that. How can you, and it does not go well with the democracy. You can't have freedom of expression, go with sedition.
Okay, but
how can you have it? It's not possible.
Okay, Mr. Venkatesh, but also there are cases where some incidents might be unacceptable. So, incitement, in case it incites any kind of violence as well, does that amount to sedition? If sedition is too harsh a charge or draconian, how could the law deal with the situation? Are you saying that it should not occur?
Incitement to violence, you have other offences. 505 is there, 153A is there, 153B
So it does not need to attract the sedition law.
But sedition has no place. Nothing called, see, the question here is this. You're talking in terms of disaffection to the government. Yeah, in a democracy, there will be disaffection to the government.
Yes.
Disaffection is that I have criticism. This government is not doing good, is my criticism. I do not have great affection for that. If the government is not doing something good, if there is rampant corruption in the government, it's a duty of a citizen to question that this government, I don't have an affection to this kind of a government. Disaffection to the government is something which is applicable only to colonial times, is not applicable. In fact, at the point of time in Kedarnath, we must also look into the kind of political history that we had. They were just young republic. They were just 15 years of freedom, 12 years of republic. And the state was being formed, largely unlettered population, very little resources. We were scrambling to make ends meet. No resources, no money. And we were looted for centuries, you understand that? And such is the case. At that time, some amount of time was required for the government to function properly. Therefore, many of the laws which were allowed to exist. For example, you have this women's right to property. When we had equality under Article 14, how can there be discrimination regarding the women's right to property in ancestral Hindu properties? That women don't have a right, only males will entitled to share in the property and not women. It's only in 2006 we got the amendment.
Yeah. So with time we need to bring in the changes to ensure that democracy is alive and thriving.
Was that, okay. So now what's happened? We have traveled distance from 1962 to 2020. We have traveled a long, long distance. In fact, you must also look at this construct in the entire region, from the Europe to the entire Asia. If there is something called a functional democracy, which is surviving democracy, it's India.
Right,
None
right.
of
So
the
these
other
are
countries
some of
have
the
this-
changes that are required. So with time, it needs to be done away with.
See,
All
let
right,
me-
all
let
right.
me- let me-
Apologies, Mr.
let
B.T.
me
Venkatesh.
explain.
We are running out of time there, but many thanks for joining us with your expertise on that. Sedition laws have been controversial for decades now. We've seen an increase in the cases, but a decrease in convictions. And this raises several questions that have been raised that need to be answered. Leave your comments on what you think on the subject as well. I look forward to that. Thank you so much for watching. Take care.